turn to the next case on this morning's docket. If you give us a moment to exchange jurists. Next case is 102573, State of Kansas v. Allendale Smith.
May it please the Court, my name is Adam Hall of Collister and Camp Schroeder in Lawrence, and today I represent the appellant Allendale Smith. Mr. Chief Justice, I would request 3 minutes for rebuttal.
3 minutes is granted.
This criminal appeal presents 4 questions to the Court for consideration. 3 of those questions are specifically trial errors that are alleged to have occurred at various stages of the appellant's trial. The appellant advances that the erroneous admission of evidence in the state's case in chief, an overzealous argument presented by the prosecutor, and an error in the instruction of the jury all operated to deny the defendant his right to a fair trial, whether those are viewed individually or collectively pursuant to the defendant's cumulative error argument. These 3 errors occasioned a 4th claimed error of multiplicitous convictions. This appeal presents an example demonstrating the wisdom of the old saying that sometimes less is more, because it is alleged here by the appellant that more was error. I'd like to begin argument with a discussion of the prosecutorial misconduct that's alleged to have occurred in this case. And I know that there were a number of arguments which were presented in written brief in this case, but I'd like to focus on 2 specific areas of argument for the purpose of this oral argument. The prosecutor in this case impliedly, at the very end of her case, impliedly referred to the state's evidence as, quote, the truth. She told the jurors that, quote, the truth will give the victim a verdict against the defendant. She told the jurors that those verdicts won't replace the victim. They won't bring him back. They won't fill the hole in his family's life, but they will give us the truth. The prosecutor's statement that the state's evidence was, quote, the truth, was misconduct. And I think for that proposition, the court need only look to State v. Elnicki, where this court, I would quote, said, for the same reason we hold it was error for the prosecutor to conclude her closing argument with, the truth shows you beyond a reasonable doubt the defendant is guilty of the crimes with which he is charged. But further, this argument demonstrates a different kind of misconduct. The prosecutor wrongfully suggested that there's a jury function of general retributive justice and not just fact-finding. She suggested to the jurors that the verdict belongs to the victim when she says the truth will give the victim a verdict against the defendant. The prosecutor also injected passion into the fact-finding process contrary to State v. Tosh, with references to the victim's family, the inability to bring back the victim. And with these statements, she sort of incites the jurors' natural passions in the case, the murder case. This was rebuttal argument. And because it was rebuttal argument, this was the very last argument that the jurors heard before returning to their deliberations. So for that reason, just its positioning in the case as a whole is highly prejudicial. There was no opportunity for defense counsel to stand back before the jurors and tell them or to mitigate that argument with any kind of counter-argument. But the other prosecutorial misconduct in closing that I'd like to highlight to the court's attention is that the prosecutor called the defendant names. She called him a snitch, she called him a liar, and she told the jurors that the defendant, quote, looks guilty. The prosecutor, in making these arguments, highlighted, expanded
Counsel, that
upon,
wasn't a reference to his appearance, though, was it? Are you implying that that was a reference somehow to his actual appearance as opposed to all of his shifting stories?
Yeah, I think it was. Of course, you're correct. I think it was in reference to Mr. Barty, the defendant's trial counsel's argument prior to the prosecutor's rebuttal argument that that his client had some character flaws, and that made his client look bad. The prosecutor stood up in a rebuttal argument and said, "Well, he doesn't look bad; he looks guilty." And I think that is the reference that I'm making. But this court has expressly previously warned against the use of the word lie or its derivatives in State v. Elnicki. And here the prosecutor uses that statement anyway. And Elnicki definitely preceded this case. The prosecutor's gratuitous characterization of the defendant as a snitch also had no bearing on the defendant's guilt or innocence. And the defendant's status as a snitch had no significance in the state's case. This was just name-calling. And that has also been previously discouraged by the Court of Appeals of this state in State v. Lockhart. It was said in response to defense argument, but I don't think that's dispositive of the question. In State v. Marshall, decided earlier this year, this court said that a prosecutor's improper comment or argument can be prejudicial even if the misconduct was extemporaneous and made under the stress of rebutting arguments made by defense counsel. The extemporaneous rebuttal nature of a prosecutor's argument is merely a factor to be considered by an appellate court.
Counsel, if we accept your argument that this was error, this was misconduct, I'd like to hear you address the standard for harmlessness.
Sure. I think that this court is then required to engage in a multi-factored analysis. It's required to look for whether or not the error was gross or flagrant, whether or not it demonstrated ill will on the part of the prosecutor, and whether or not the other evidence was overwhelming. I think it's...
Were the credit cards of the victim found in the possession of your client?
There were credit cards found. I think that may have been the case. I know that a wallet was found at the accomplice witness's location. I believe a credit card was found behind or in a levee somewhere. And it is possible that there was incriminating evidence.
I think more than possible that there was some incriminating evidence that he also had confessed to a string of burglaries in this time frame with this gentleman that was his accomplice who testified against him.
Yes.
Okay, so how do we get to this being reversible prosecutorial misconduct as opposed to harmless?
Sure. I think that Your Honor's comments go to the nature of the other evidence. Was that evidence overwhelming?
Third prong of harmlessness, I think.
Yeah. I would say it wasn't. Obviously, the record on appeal in this case contains evidence of a prior trial, which resulted in a mistrial by virtue of a hung jury. So I think for that reason, for that sort of evidentiary reason, it becomes difficult to conclude that the evidence was overwhelming against the defendant. But also
the evidence in the first trial differ from the evidence in the second, if at all?
It didn't.
Okay.
The arguments were a little different, I understand. But the other issue is the nature of the evidence presented against the defendant. I mean, this court would caution jurors against putting too much credibility into the testimony of an accomplice witness, and I think that's significant. I also think the circumstantial evidence, which formed the body of the state's evidence, is significant. I also think it's significant
the fact that it is circumstantial, you mean?
Well,
as opposed to direct?
Right, versus direct. And the only direct evidence...
We convict people on circumstantial evidence all the time, don't we?
Sure, you do. But I also think it's significant that the state resorted to the use of KSA 6455 evidence. And I think that if you look at the instructions in the pick for 6455 evidence, it would be improper to use that evidence in a case where the evidence was otherwise overwhelming. I think that the Judicial Council has cautioned prosecutors against that.
Yeah, not to pile on.
Right.
Let's talk about the 6455 a little bit.
Mm-hmm.
It was admitted for identity. That was the factor that the jury was instructed to consider it for.
That's correct.
Why doesn't that work here?
Well, I think the judge relied upon 6 different factors in determining that these other burglaries had a quality of sameness that would aid the jurors in reaching the conclusion that it was the same person involved both in this burglary and the subsequent burglaries. I think
Let me ask you a preliminary question, just in terms of how the evidence came in here. Was there a dispute as to whether there had been anyone with Price?
There was, and I think the judge appropriately...
So there were 2 questions. Was there anyone with him? And then if there was someone with him, was it your client?
That's correct. And I think the trial court enunciated those disputed facts.
Okay.
But then the trial court laid out, in deciding to admit 6455 evidence, 6 what he termed similarities that would justify allowing the evidence in. He determined that they all occurred at rural residences. They all involved ransacking of a residence with no particular property being targeted, that firearms were taken in each burglary, that the burglaries took place within a driving distance of Topeka, and that all the burglaries were committed by the accomplice witness Leonard Price. He also determined that the burglaries took place over a short period of time. I think that with the exception of that last factor, the other factors are substantially undercut, and that by Price's testimony, both in the pretrial proceedings and at trial, when he says, this was my MO. I mean, this is what I did
with or without Mr. Smith.
Without Mr. Smith.
But wasn't there a distinction there that struck me as significant in that he said he didn't steal credit cards or checks because he was afraid that would come back to him.
He did.
That this defendant did that. And in fact, there was some evidence that in the burglaries he had done that, and they were able to trace the checks and other and I think we've mentioned that there were credit cards found from this burglary, correct?
That is correct.
So
that is not.
Why is that not significant as we look at this?
Obviously, if the review is unlimited, that is very significant. But here, that was not one of the similarities relied upon by the district court, which would tend to establish whether or not Mr. Smith was present at this burglary. So I think for that reason, I've alleged that there was error there. Now, there may be other factors that the court didn't consider that this court might find significant to ultimately determine the error was harmless. But in this case, I think that the court did commit error when relying on these other factors that really had no tendency and reason to either place Mr. Smith at the scene of the burglary or not place him at the scene of the burglary. And as you mentioned, that the disputed question was identity and the number of burglars at that particular burglary. But in addition to the sort of, I would call it questionable relevance of the factors relied upon by the district court, there's a question of prejudice that I don't think was addressed by the district court when it comes to the Pottawatomie County burglary, where Mr. Smith fired on a gentleman who intervened in the course of that burglary with a firearm. And I don't think the court, or it does not appear the court considered the individual prejudice of that particular burglary in deciding whether or not to admit the 6455 evidence.
Was he asked to do so by the defense?
No, was not.
Okay, thank you.
I see I'm running out of time. If your honors have any questions, I'm happy to answer them.
Any further questions? Thank you, counsel.
Thank you.
Good morning, Your Honors. Charles Branson, District Attorney for the Appellee. If I may, I would like to take this in a reverse order as to what counsel did and start with the 455 issues. The evidence was relevant material to identity in this case for several reasons. One, the similarities that the district court pointed out, but most importantly,
Counsel?
Yes.
Would you agree, though, that the majority of those listed, first of all, would you agree with your opposing counsel on what the list was as given by the district court?
I think that's generally accurate, yes.
Okay, it looked like a fair summary to me, or sounded like one today. So that leaves us with two similarities that actually have something to do with the defendant here, as opposed to anyone who might have accompanied Mr. Price. And one is the fact that this defendant admitted that he'd participated in several other burglaries with Mr. Price in that time frame. So we've got the time frame similarity that actually points to Smith as opposed to someone else.
Right.
And then we have what my colleague just pointed out about the fact that Price said, I didn't take credit cards and checks because that would be stupid. They would point to me when they were attempted to be used, whereas Mr. Smith apparently did have that as part of his repertoire.
Correct.
But the other items really aren't about Smith, are they? They're about general MO that Price said he engaged in by himself or with others as well, right?
Yes and no. I think there's a subtle difference there. You have to look at what kind of crimes are being committed. If you look at any general rural residential burglary, how are they committed? You'll probably find that there's been a door kicked in. You'll probably find that anything that's easily pawned or sold is what's taken. you'll find, they happen in daylight, they happen in the country, all those types of particular things. So I think you have to be careful a little bit about making a distinction about, just exactly how these similarities play in. And you have to look at really what are the true similarities. What are the things distinctive about these other crimes that tend to show identity in this case? And they are just exactly what you've identified.
Those two things. The other things, I think what you just told me is they're very common. It's like in a molestation case where the victim's told to keep it a secret. Well, the victim's always told to keep it a secret. So that's really not a distinctive element. And if the rural burglary, as you say, has a pattern that was not distinct here, then the fact that these were all rural doesn't really help you.
They're similar, and I think it's something that needs to be considered. Definitely, they go along with this case. But I think that the linchpins are, just as you have identified, what makes this information relevant and material to this case are the facts that the two before the Booth robbery or burglary were committed with Smith. The one after in Potawatomi were committed with Smith. The close time frame, defense counsel at trial made a long production about saying, well, you've been doing this for 20 years, and this has always been how you've done it. Well, that's true, and it wouldn't be relevant if that's all we were talking about. But the fact is, we were talking about 3 other cases closely associated in time,
within a few
packed
days,
in
right?
around.
Within a few days.
They started on, I believe, the 25th. There was one on the 26th. This happened on the 29th. And then the Potawatomi County case happened, I believe, on May 3rd. These two were out committing this, if you will, crime spree. And what makes this relevant and material to this particular case is that closeness in time. The fact that Smith has admitted to the 2 robberies before, the robbery afterwards, those similarities along with Price's testimony. And again, exactly what you said with regard to the financial issues, Price was adamant that anything financial wasn't going to be anything he was going to get into.
Am I right, too, that Smith said that they were committing these crimes to get money for drugs? That
Correct.
was supposed to be the motivation, right? Okay.
Correct. And the motivation for the Potawatomi County on May 3rd was to essentially get money to flee after the Booth
The later
homicide.
one. Okay.
Because they knew they were being looked for at that point in time. The Potawatomi County robbery had gone horribly, well, not as horribly wrong as the Booth burglary did, but close to it.
Okay.
So I think under those circumstances, it's very important to look at that as a whole and say that these are clearly relevant material. It'd be almost absurd not to bring these things into the case. One additional comment I'd like to make with regard to the 455 is there was a limiting instruction given. I know counsel has complained of the limiting instruction. And I will tell the court I did not write the brief in this matter, but in preparing for the arguments, I was going through that and I thought, there's something wrong here. There's something missing. And what was missing was the fact that the defense trial counsel requested specifically this instruction in the first trial. That's contained in the record on volume 20, page 1406 through 1414. He specifically goes through a long issue about why he wants defendant's identity taken out and wants it changed just to identity, and the court granted that request after he made that request and some strenuous argument for it.
First trial.
In the first trial.
But we're talking about the second trial.
Your Honor, and I will tell you, being one of the 2 attorneys in the trial, those jury instructions were simply just transferred over at the jury instruction conference. We picked up the instructions that we used in the first trial.
Well, on the second trial, was the closing argument by the state different? In other words, the things that are complained about today by Mr. Smith, were those present in the first trial?
Are you referring to the...
let's just say the defendant called a snitch in the closing argument in the first trial?
I can't remember specifically off the top of my head what Mr. Barty indicated about his client in the first trial. It was something somewhat similar. Obviously, both sides had different arguments at closing or different variations of their arguments at closing.
Well, you see where I'm headed. If we have a hung trial or a hung jury, a mistrial in the first, and then we have improper statements made in the second trial, and it results in a conviction, and then you say, well, it didn't affect the outcome. It's a little hard to say that. If basically the same evidence came in and you had the same trial twice, the only difference being improper argument, it's difficult to say, oh, well, that's as beyond a reasonable doubt or whatever harmless
Having lived through both trials, I can tell you they were different trials. Obviously, that statement's not contained in the record, but there were different strategies, different questions asked from trial to trial. In fact, the second trial, and I cannot recall, I was just trying to remember as I was sitting there, it was either Tim James or Blodgett that were not called in the first trial, and I do not remember which.
Those were the two jailhouse informants, right?
Correct. Those were the two witnesses that were in custody. I kind of hesitate on the jailhouse informant in the sense that they were not given anything for their testimony. They were not brought under any promises or anything like that in this case. I would like to transition a little bit into the comments about the misconduct. The counsel is tried to link the entirety of my co-counsel's hour-long closing into a colloquy that was very prejudicial. One of the things I would like to point out is counsel has taken this colloquy and taken these statements out of context and, in fact, taken them out of order. The first complained of comments by counsel with regard to the believability of Leonard Price. He then goes on to say the prosecutor then made an appeal to the sympathy of juries. But if you'll notice the cite in the record, that actually occurred 15 pages in the transcript before the first complained of comments. These comments were appeals to the jury to quite simply look at the evidence. How do we know this person is guilty? And if you look at each one of those statements in context and go and follow the transcript along with those statements and what was said afterwards, they are just that.
What about the truth?
The truth.
What about the truth? That's improper, isn't it?
Obviously, this case was tried 4 years ago. Since that, before that time, Elnicki came out with obviously the prohibitions against that type of statement. Martinez has since come out, and Anderson, of course, in May of this year has come out with issues very similar to this. I would have to concede to that extent that this type of comment is now frowned upon by the court, and it's deemed to be an improper comment. Having gone through those comments and asking the court to look at each one of those in context, I think we do get to the analysis of if that comment with regard to the truth argument is deemed to be an improper comment, then we have to look at the analysis with gross and flagrant ill will, and did it make any difference to the jury? Unlike, for example, a case that was cited in secondary information, the Anderson case, where a case similar to that was coupled with what was deemed to be a belittling comment about the defendant. There is no belittling comment. I know the counsel would like to bring in this liar and snitch issue. Frankly, that was created by defense counsel. Defense counsel said, my client is a liar, my client is a snitch, he's a burglar, he's done all these things. And counsel simply stood and said, well, he said that, but let's think about why he said that. And then it goes on to a colloquy of the snitch, first one in the door. Why did he come to the police and tell? Because he wanted to get away with the crime. So there's no evidence of ill will in those comments. There's no evidence of gross or flagrant based upon those types of statements. They just do not follow into this analysis. Would the comments have made any difference?
In other words, here, unlike many cases where you have the defense counsel standing up and trying to make their client look good, this defense counsel's approach was to say, I got a bad guy, but he's not that bad. And so your rebuttal argument, not you personally, but your co-counsel's rebuttal argument said, yeah, he's a bad guy. You heard his counsel. In other words, you don't have a situation where it's responsive to the defense argument because the defense has tried to make the defendant look good. It's responsive to the defense argument only in the sense that he was agreeing with defense counsel.
True, and Mr. Barty did a very thorough and well thought out plan with regard to that.
He was doing damage control.
Right, there was no way he was going to make his client likable, because the jury had this information. They knew what he was like and what he had done. There's no way he was going to make him likable. He was just going to say he wasn't guilty of this crime. And that was really his thrust there is, we're coming in, we're admitting what we've done. We didn't do this one. So yes, I'm
credit for honesty.
Right. So I am a burglar, I'm a snitch, I'm a liar, but not this time.
Not a murderer. Okay, thank you.
And, with that, the changes in trial from the first to the second, the comments that are made here, frankly, the evidence is very strong in this case. Once you put all those things, there's no error in the 6455 issue. That information was proper to be brought in. It was not piling on. Exactly the opposite. It was necessary. So it wasn't a matter of piling on to try to make somebody look worse. It was bringing information forward that was relevant material to say, hey, this person was in fact involved in this crime. Given that type of information, the evidence in this case, I think the jury made an appropriate decision, that the evidence was such that any of the comments by the prosecutor conceding that the truth, although there was not any type of demeaning comment coupled with that, has been some of the prior cases, the jury could not have been misled by this and had little weight in the minds of jurors.
We had some 609 letters alleging that the same prosecutor had done some of the same things or said some of the same things. What can we do with that? Or does that factor in, or can we consider that, or in that form in the 609? Obviously, it seems to me that it's a little difficult to argue no ill will or it's not gross and flagrant. If it's repeated, it indicates some premeditation and planning.
Your Honor, and I fully understand and expected that question, quite frankly. The reality of it is, if you look how old these cases are, the Anderson case I specifically brought up because that was attached in the 609. That case was tried in 2007. This case was tried in 2008. The court has clarified all these issues since then in 2010, and obviously Anderson came down in 2012.
So your response is that even though it happened more than once, it hasn't happened after appellate clarification that it was wrong.
Correct. I think counsel tried to bring up a local district court case that was granted a new trial for cumulative error, that an error was suggested. There had been an amended decision in that case that went directly against counsel's second supplemental letter. I think, again, Your Honor, as we would say with any case, you decide the case on the facts. You wouldn't hold a defendant responsible for other malfeasance. And in this case, just like any other case, has to be decided on the facts before the court, in this case solely. Your Honors have no more questions. I'll retire.
That's it. Thank you.
Thank you.
May it please the Court. I, while sitting at counsel table, took an opportunity to review the brief. I know that it was significant to Your Honors that Mr. Price testified that he did not like to take financial instruments because they might link him to the scene of the crime. But I would direct Your Honors to page 18 of the brief of the appellant, where there's an exchange occurring at trial between defense counsel and Mr. Price. And one of the questions contained there, and that can be found in the record at volume 24, pages 698 to 699, counsel is conducting a cross-examination with the same purpose, to establish that the MO of Price is the same as the MO with Smith is the same as the MO of Price by himself or with anyone else. He asks Mr. Price, that is defense counsel asks Mr. Price, and when you did it without Alan Smith, you're looking for basically the same sort of stuff, answer yes. So I don't think it's so easy to put the blanket on there that Mr. Price never looks for financial instruments. If he was looking for them with Mr. Smith as well, he says that his MO was otherwise the same. I think it's significant, returning to prosecutorial misconduct, that my esteemed colleague argues, well, she being the prosecutor, didn't conduct any misconduct that she knew would be wrongful. But I think it's significant that El Nicky was decided in 2005. El Nicky was clear in saying, don't say the truth in reference to your own case. And if you look at the one paragraph where the truth is used by the prosecutor in this case, she says it 6 times. And to me, that suggests gross and flagrant misconduct on the part of the prosecutor in this case. I would concede that when briefing the issue of misconduct, I didn't necessarily put it in the order as it appears in the record. I don't think that would affect the argument advanced by the appellant. And when it comes to whether or not defense counsel requested a jury instruction, a limiting instruction on the 6455 evidence that departs from the PIC, I think if you review the appellant's argument, it's an argument that doesn't only address the instruction's departure from the PIC standard instruction. I mean, it attacks the PIC when it comes to this issue, which is you have to tell the jurors that they can't use the evidence for mere propensity. They can't assume that because this is a violent burglar, he was there. They can't assume that because he was a burglar, he was there. And they can't find or infer that because he's a criminal that he was at this crime. And I don't think that the PIC warns the jurors that they can't use the evidence for this purpose. So I don't think it's significant that defense counsel requested a deviation from the PIC. And again, I'm out of time, unless the court has any questions.
As a practical matter, the limited instruction is not really enlightening, is it? The jury doesn't know what preparation means. They don't know what identity means. We have, they're not aware of strikingly similar versus similar. So we're really talking academically here rather than practically, aren't we?
I suppose that is the case. In preparation for this argument, I also examined the 10th Circuit's pattern instruction for similar cases. The 10th Circuit adds a line that says, of course, just because a defendant commits a crime on a specified occasion does not mean that he committed a same or similar crime on a different occasion. And I think that language would have been beneficial in this case. It would have tended to suggest to the jurors that they can't use the evidence for mere propensity, and because they were not so warned, that error is suggested. Thank you, Your Honor.
Thank you to both counsel for your arguments. We'll take this matter under advisement. The court will be in recess for 15 minutes.
All right.